The opportunity for further questions. The Honourable Member for St. Albert Edmonton.
Thank you, Madam Speaker. At the beginning of her speech, the Minister stated that irremediability is not up for debate. Respectfully, it is the core of the debate about whether MAID can be expanded in cases where mental disorders are the sole underlying condition. And the overwhelming evidence from leading experts, including psychiatrists, is that it is difficult, if not impossible, to determine irremediability. That was the conclusion of the government's own expert panel at page 9 of the report. The Special Joint Committee heard evidence that clinicians could get it wrong 50% of the time. In other words, it's like flipping a coin. Flipping a coin with people's lives. Is the Minister comfortable with that risk?
The Honourable Minister.
I will thank the member for his question, but I will remind him that we can't speculate on treatment. Treatment is something that a patient decides with their healthcare provider. There is a lengthy process and of assessments that are done for those who struggle with mental illness. That being said, the criteria in terms of eligibility are crystal clear. It has to be prolonged. It has to be determined irremediable not only by the patient, but a group of expert assessors, a full assessment of what treatments have been engaged. And I know there's been some debate in the House in the past of, well, what about future treatment and all of that? We are looking at an individual and their prolonged suffering. I would ask the member to really contemplate on does an individual's own lived experience with prolonged mental illness and the suffering that goes with it not weigh in beyond the experts who haven't walked in their shoes?
Resuming debate, the Honourable Member for St. Albert Edmonton.
Thank you, Madam Speaker. Here we are again, just as we were last February, faced with an arbitrary deadline set by the Liberals for their radical plan to expand MAID for mental illness, with a Liberal government completely unprepared and therefore needing to bring in 11th hour legislation to extend the implementation deadline that they set in the first place. Madam Speaker, I can't think of another time or another issue in which a government has had to bring in effectively emergency legislation twice to extend a deadline for the implementation of their own law. It's truly shambolic. How did we get into this mess thanks to the Liberals? Well, very simply, what we have across the way is a radical and reckless government, a government that put blind ideology ahead of evidence-based decision-making. That has been the consistent pattern in terms of decisions this government has made with respect to this planned expansion, starting with David Lametti, the former Justice Minister, who accepted a radical Senate amendment back in 2021 to implement MAID for mental illness, and then that set a arbitrary 2-year timeline for implementation. And it should be noted that the charter statement for the bill, in which Lametti accepted that radical Senate amendment, provided a rationale for excluding MAID in cases of mental illness, and the minister at the time said that he was against, and the government was against, MAID for mental illness because there were inherent risks and challenges. Indeed, he was right. But then he suddenly flip-flopped and rammed the amendment through with very little debate, 1.5 days of debate, no parliamentary study, no consultation with experts and affected groups, and no evidence that MAID for mental illness can be implemented safely and appropriately. The Liberals got it completely backwards. Instead of studying the issue first to determine whether this could be implemented safely, they decided to move full steam ahead and study the issue after the fact. Had they approached this matter responsibly, they would have learned very early on that there are significant clinical, legal, and ethical problems with expanding MAID in cases of mental illness. Among those problems are two fundamental clinical issues. The first is the difficulty of predicting irremediability. In other words, it is difficult to predict whether someone with an underlying mental health condition will not get better. That is problematic in two major ways. One is from the standpoint of the law. Under the criminal code, in order to qualify for MAID, a person must have an irremediable condition. More specifically, an irremediable condition is defined as one in which one has an incurable disease or illness and is in an irreversible state of decline. If it is not possible to accurately determine whether someone with a mental illness is in an irreversible state of decline and will not get better, then from the standpoint of the law, how can MAID for mental illness be carried out within the law? It can't. More significantly, from an ethical standpoint, if it is difficult to predict whether someone will get better, what that means with certainty is that persons who could get better, who could go on to lead a healthy and productive life, will have their life prematurely ended. That was underscored by evidence heard by the Special Joint Committee on MAID, both during its initial study 2 years ago and its more recent study this past fall. Among the evidence that the Special Joint Committee heard is that clinicians can get the prediction around irremediability wrong 50% of the time. In other words, it's like flipping a coin. Flipping a coin with people's lives. Is that a risk that members of this House are prepared to take? When I posed that question to the Minister responsible for mental health, she essentially answered in the affirmative because she doubled down in her support for an expansion of MAID for mental illness in 3 short years. Flipping a coin, gambling with people's lives, that's what MAID for mental illness will result in. And a second fundamental problem is the difficulty on the part of clinicians in distinguishing a rational request for MAID from one motivated by suicidal ideation. That is underscored by the fact that in 90% of suicide deaths, persons suffer from a diagnosable mental disorder. Not to mention that suicidal thoughts are often a symptom of mental disorders. It's why psychiatrists who appeared before the Special Joint Committee said that it is not possible to distinguish MAID and mental illness from suicide. At the very least, MAID for mental illness significantly blurs the line between suicide prevention and suicide facilitation. It fundamentally changes the character of MAID in transforming it into something akin to state-facilitated suicide. it demonstrates just how far down the slippery slope we have gone under these Liberals. And the minister said that there are robust safeguards in place, that persons with a mental illness would only be able to qualify after years in which they had received treatments in which they were not getting better. Well, that is paraphrasing what she said. Madam Speaker, that is simply not accurate. It's not accurate because no such safeguards are in any legislation put forward by the Liberals. In fact, the expert panel that the Liberals appointed incredibly recommended that there be no additional safeguards. And so, under the MAID expansion, it's simply not accurate that in order to qualify, that one must go through treatments or that they must be suffering over an extended period of time. In fact, the Liberals expressly rejected additional safeguards such as that. Now, Madam Speaker, in the face of those challenges, clinical challenges, Conservatives called on the Liberals to put an indefinite pause on this expansion. Likewise, in the lead up to the March 2023 deadline for implementation, that arbitrary deadline set by the Liberals, the chairs of psychiatry at all 17 medical schools called on the Liberals to put a pause on this expansion. And what did the Liberals do? Well, essentially they kicked the can down the road. They introduced Bill C-39 that merely extended the deadline for implementation from March of 2023 to March of 2024. In other words, once again, the Liberals put ideology ahead of evidence-based decision-making, making what amounted to a political decision with a new arbitrary deadline. Nearly a year has passed, and where are we today in terms of resolving the fundamental issues and problems with respect to safely implementing MAID for mental illness? The answer is that no progress has been made. Indeed, when the Special Joint Committee heard from psychiatrists, the message was loud and clear: don't move ahead with this, it's not safe, it can't be implemented appropriately, and that the responsible course for the government to take is to acknowledge that they simply got it wrong and to put an indefinite pause on this expansion. It's no surprise that in the face of these challenges, that if there is a professional position or a professional consensus, it is a consensus against this expansion. We saw that last week when a survey from the Ontario Psychiatric Association was released indicating that a full 80% of Ontario psychiatrists don't believe that the healthcare system in Canada can safely implement MAID for mental illness. And last week, 7 health ministers, 7 out of the 10 provinces, plus health ministers from all 3 territories, called on the Liberals to put an indefinite pause on this expansion. And what did the Liberals do in response? Well, once again, they kicked the can down the road with Bill C-62 now before us, defying experts, defying the provinces and territories, and defying common sense. This bill is basically the same bill we were debating a year ago. Instead of a 1-year pause, it provides a 3-year pause, with there being absolutely no evidence to indicate that fundamental clinical problems, including predicting irremediability and distinguishing between a suicidal request versus a rational request, can be resolved. And so what we have is a government that saying, forget the evidence. The minister said it's not even up for debate. We don't even want to talk about evidence as part of this issue. Irremediability, forget about it, she basically said. And so we have a Liberal government that is determined to implement this radical policy. That's the bottom line, against a consensus amongst psychiatrists and other advocates. Indeed, to get an insight into the mindset across the way, the Minister of Health last week in a press conference said that there is a moral imperative to get ready for MAID and mental illness. A moral imperative. A moral imperative to do what? A moral imperative to give up on people who are struggling with mental illness? Shameful. A moral imperative to offer death through the provision of MAID to persons who are struggling with mental health issues? That's what these Liberals characterize as a moral imperative. I say it speaks to the moral bankruptcy of these Liberals after 8 years of this Prime Minister. And, Madam Speaker, when the Liberals talk about MAID and mental illness, they're always very vague about what they mean. They know that if Canadians knew and fully understood what MAID for mental illness meant, most Canadians would be absolutely appalled. The model practice standard that I believe the minister alluded to, that was prepared by the government's so-called task group of experts, provides that for a mental disorder, that would include anything in the DSM-5. Any condition listed in the DSM-5 is what these Liberals are contemplating as constituting a condition that would qualify someone for MAID in the case of mental illness. And so what are the conditions listed in the DSM-5? They include personality disorders, depression, schizophrenia, issues when persons suffer from and have addictions, challenges. That is what we're talking about when it comes to MAID and mental illness. It is truly repulsive. It's morally bankrupt to the core, and it says everything that Canadians need to know about the values of these Liberals. Madam Speaker, there is only one piece of good news in all of this, and that is that this legislation provides a 3-year pause, and what will happen between now and the expiration of those 3 years is a federal election. Hear, hear. And so Canadians will have a choice. They can choose between a Liberal government that wants to provide death to persons who are struggling with mental illness, or they can choose a common sense conservative government. A common sense conservative government that won't give up on anyone, that will be committed to offering persons struggling with mental health issues hope and health, and yes, a common sense conservative government that will permanently scrap this radical liberal experiment that gambles with the lives of vulnerable Canadians. Thank you, Madam Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Health.
Thank you. Thank you very much, Madam Speaker. And I was listening to the member quite intently. And there's 2 points that I want to raise quickly and hear his response. One, he talked about a consensus between, in the psychiatric community, and I don't know what consensus he's referring to. There are various varied views on providing services and cure to people with mental illness. But my question regards to rights of individuals. We've got a decision by a Quebec court that has required this Parliament to act on that ruling to ensure the rights of individuals that's guaranteed under the Charter of Rights and Freedoms are protected. I would like to hear his views as to how we will reconcile with those rights and what would be his plan to ensure the rights of Canadians, whether they have mental illness or not, are protected under our Charter.
The Honourable Member for St. Albert Edmonton.
Thank you, Madam Speaker. I would submit that 80% of psychiatrists in Ontario saying that MAID should not be expanded in the case of mental illness is approaching a professional consensus, and the member, I would hope, would be concerned of a government policy to expand MAID in cases of mental illness, significant expansion impacting vulnerable persons, that he would question the appropriateness of such a policy in the face of opposition from so many experts. And with respect to the Quebec court decision that he alluded to, he is, I believe, referring to the Truchon decision, and there was no pronouncement of the Quebec Superior Court on the question of mental illness. That was not part of the fact pattern in the case. The plaintiffs were not suffering from an underlying mental health disorder. There's no precedent, no binding precedent, no precedent forcing this government to enact this legislation. This is a political decision made by these Liberals.
Yes, Jonesy, come on.
Questions and comments.
Malahat Langford.
Thank you very much, Madam Speaker. As my colleague knows, I've been on the Special Joint Committee on Medical Assistance in Dying from the get-go. And if he will recall, in the 43rd Parliament, when this House was dealing with Bill C-7, the government's original charter statement, which provided its rationale for excluding mental disorders as the sole underlying medical condition, I thought was fairly well reasoned and explained that, yes, Section 7 and Section 15 of the Charter can be involved here, but, we have to remember Section 1, and sometimes we may need to limit rights. For me personally, I'm a big believer in the Charter, but I struggled through this whole process and how I find that balance between an individual's Charter-protected rights, but also the need of society to sometimes step in and protect the most vulnerable. And I would just like, through you, Madam Speaker, to wonder how he personally approached finding that balance, and to also put it in the context that so many people in Canada, whether they are in rural or remote communities or in our urban centres, are marginalized and don't have access to the proper mental health care supports that they so desperately need. Thank you.
The Honourable Member for St. Albert Edmonton.
Thank you, Madam Speaker, and I want to thank my colleague from Cowichan Malahat Langford, who I enjoyed working with on the Special Joint Committee, and the manner in which I approached this issue is by following the evidence to determine whether this expansion could be implemented safely and appropriately. And the overwhelming evidence is that it cannot. And it need not have been this way. We need not be here for a second time on the eve of an implementation date that was arbitrarily set by the Liberals. We could have studied this issue. We could have heard from experts. We could have heard from other groups about this without moving ahead with legislation before undertaking that important consultation. And so, Madam Speaker, let me simply say that this government has gotten it backwards, they've gotten it wrong, and what they should be doing is coming back to this House and putting an indefinite pause on this expansion.
Questions and comments. The Honourable Parliamentary Secretary to the Government House.
Yes, Madam Speaker, I think the member is not fully online on this in the sense that there is a Quebec court decision, and that decision does put in a deadline that the government does need to respect and respond to. And this whole process, and I remember at the beginning of his arguments, the member was talking and trying to pass the blame. Let me remind the member that it was Stephen Harper, the same government in which he worked for, I must say, Madam Speaker, back in 2015, that chose to do nothing and ignore the issue. And that was based on a Supreme Court decision. And I'm asking the member, would he not recognize that you can't just ignore the issue? That is the track record of the Conservative Party.
St. Albert, Edmonton.
Well, Madam Speaker, if the member is referring to the Truchon decision, that was not what the Truchon decision provided for. That was outside of the scope of the Truchon decision. And evidenced by that is the fact that when the Liberals responded to Truchon by introducing Bill C-7, mental illness as a sole underlying condition was expressly excluded from the legislation in response to that decision. This is a political decision brought on by the Liberals.
Honourable Député de Montcalm.
The Honourable Member for Montcalm. Madam Speaker, my colleague is always quite eloquent in defending the no camp. Does his position represent his party's? Is that the official position of the Conservative Party? I think that would be important for us to understand the issues and the stakes in this debate, because what I'm hearing him say basically is that irremediability is something that can never be proven. And so people who are suffering intolerably, who are dealing with intolerable suffering, because they're victims of a mental illness, they will never, if there's a Conservative government in power, they will never be able to see their suffering alleviated. That's what I'm hearing. Am I also to hear that he proposes to fix or solve this problem of irremediable and intolerable suffering by injecting a whole bunch of money into the healthcare system so that access to healthcare is something that is going to be completely forgotten, a thing of the past, that kind of suffering? Is that what he's telling us? The Honourable Member for St. Albert, Edmonton.
Madam Speaker, and I want to thank the member for Montcalm, who is a thoughtful member on this issue. What I would say with respect to the question of irremediability is that I am absolutely not comfortable with moving ahead with this expansion if it cannot be accurately determined. When psychiatrists come before a committee and say it's like flipping a coin, that clinicians get it wrong 50% of the time, that is not an appropriate risk. That is evidence of a policy that has not been well thought out and that is dangerous and will negatively impact vulnerable persons on a matter of life and death. And with respect to the position of the Conservative Party, yes, the position of the Conservative Party is that a common-sense Conservative government will permanently scrap this radical and dangerous expansion.
The Honourable Member for Fundy Royal.
Madam Speaker, thank you to the Honourable Member for his